put my comments in writing. So for the new clerk who I don't know, I'll give you a copy of the summation to make your life easier, especially if you haven't done it. And you're welcome to chuckle. I take no offense to that. I have a copy for each of you. And you're welcome. Can you pass that to me? That's for, I have an extra. Page 1, top of the page. Sean Murphy, Sherman Hill Road. I'm for and against parts of this. Under the definition of political signs, the proposal for 7.5.4.0, you can add as a suggestion, I read the minutes from last month about for a matter of controversy as a potential definition to this. That was just a suggestion, since that is something that does come up in political signs in town. For the proposal for 7.5.10I, the town attorney has covered kind of where my comments were, but I went and looked this up. Back in, I would say, 2012, it was some point in my tenure here, which started December 2011 and ended in May. At some point in there, Mr. Miller gave a document entitled Modern Constitutional Issues in Sign Regulation. Page 4 of that says the following, quote, "The courts will not tolerate display time limits on political speech, whether related to an election or not. Reasonableness of the display time period is not the issue. Political and religious speech must be allowed at all times," which is where I get my request to remove the second sentence, which it's been talked about, but that's what I wrote. Another potential suggestion, which will go to Mr. Overton's question, Mr. McNally, about the state interest in doing all this. You could potentially create a section 7, and this, for some reason, the autocorrected the dashes instead of the periods. 7.5.9D. No sign shall create a safety hazard, including but not limited to blocking the line of sight and driveway. I will come back to some issues that have been brought in front of this commission where the commission does have a right to regulate sign. Excluding those issues, this is the appropriate bill to pass, or the appropriate regulation to pass. Item number 1, and this is a quote from a legal opinion given to this commission from November 9th, 2010, from Attorney Roberts. "Because these restrictions on political signs contained in section 7.5.10I are greater than those applicable to commercial signs, I believe there is a significant risk that those restrictions would be found to constitute an unconstitutional restriction on free speech." The perspective on this, the role of an attorney in a legal opinion is to give sort of risk management and say, well, this is what will happen if it goes to court, or what's likely to happen, which is why his language is so vague at times. But this was very clear, and nothing has ever been done to address that. And what has been done since this legal opinion, back in March, which is under on the bottom of the page there, second to last paragraph of page 1. In March 2013, under application 12-ZC-1207, the Zoning Commission passed a change to Regulation 7.5.10C, which allows an unlimited number of contractor signs, and I wrote in parentheses of 4 square feet. This commission was told that you cannot restrict political speech more than commercial. The commission determined almost 2.5 years later that it was going to allow an unlimited number of signs in terms of square footage, an unlimited amount of square footage of contractor signs. To not remedy this by removing the restrictions on political signs, the only remedy here is removing it. There's nothing else this commission can do to be consistent with the town attorney's opinion.
Can I ask you to clarify something?
Absolutely.
When you said in response to this legal opinion dated November 9, nothing was done, something was done.
Okay.
I'm interested to know why you said nothing was done. In direct...
Nothing was done
Can I have the floor while I finish my sentence, Sean?
Fine, go right ahead. Sure.
And in direct response to this legal opinion, this commission drafted language which said, and I quote more or less, I paraphrase, that no restriction to political signs would exceed those for commercial signs in the particular district. That was our, as a commission, response to this. How can you sit there and say nothing was done? We changed the regulation to respond exactly to this. We went round the horn for 18 months.
First of all, what you said is not true.
Which
I was on this commission, I'll tell you it's not true, since you asked. You wrote the first change after this November 9, 2010. I'm testifying and answering your question.
You already been testifying.
You were the sole person involved in writing that first draft, which was a greater, I don't have the exact text, but it's been done so many times. That was, you wrote that, not the commission, and the commission threw that out in February 2012 after it went on for that.
For the record showing you're half right. I didn't write it. Attorney Roberts wrote it and gave it to us through the planning staff. I have the email. I didn't create it.
I have the email.
But the second part is true, that this commission did reject it entirely. Correct. That is why we're here today, because we went through that loop of trying to comply with Attorney Roberts' opinion by saying you can't discriminate against commercial speech by having larger political speech and vice versa. That was his point. It was a question of discrimination. It was an equal protection under the law requirement, not a free speech requirement.
It was, well, whatever it was, you asked me a question, and there's a bit I would add in my statements. And the proper remedy was not done after this legal opinion. That would be the accurate thing to say. That's what started this.
I believe that what the commission did in utilizing a draft given to us by our attorney was correct and remains correct to this day. I still believe it.
I will, if I have to, I will pull the email out, and what the attorney did was say, here's something you can use, but I don't suggest it. So you're telling half the story. I have the email.
Yep.
I've read this email at this meeting.
Yep.
What I want to state, like you had said, the issue here is the current regulations. We can have a discussion about that another time on passion. The issue here, in adding, to answer your question, what should have been done, and I have more to go through here, it's 2 pages, and I'll get to it. What should have been done on that spot was remove the restriction. That's what should have been done.
In your opinion. That's your
Well,
testimony.
I'm making the case on why that should have been done. And you are correct in asking for a reasonable clarification. I think I gave it. I'd like, if I could, go back to item 2, which is on the beginning of page 2. The bigger issue that was not being addressed when Mr. Overton was just speaking earlier about regulating political signs is Connecticut statutes. And there is no authority under state statutes to regulate political signs. Under section 8-1A, the state grants powers to local municipalities. And I'm going to read you I actually cut and pasted it from their website. What I don't have is the accurate legal symbols, so I'll have to be forgiven for that. Zoning commissions. A. Any municipality may, by vote of its legislative body, adopt the provisions of this chapter and exercise, through a zoning commission, the powers granted hereunder. I added emphasis of granted hereunder. From this language, the zoning commission in Woodbury has to be given permission to regulate a matter. I've read section 8-2. The only reference to signs is advertising signs. There is no reference to regulate political signs. That is how state law works. That's not an opinion, that's just how it is. You have a pecking order. And this says it right here. The words are granted hereunder. You have to be granted this right. You have 1.5 million things, and it's like 5 pages long.
Sean, as a matter of law, we're all lawyers at some point or other, but as a matter of law, I'm interested in your opinion, because what you just said, I don't think is accurate.
Well,
why don't you finish the question?
You're arguing with my testimony, and you've interrupted me 4 times.
I want to clarify it.
I want to finish what I'm saying, which I have the right to do, and then I'll take any questions you like.
I think your testimony is unclear.
Because I haven't finished it, Mark. I'd like to finish. And I address it, and here's where I address it. And it says it right in this document. As one can see from this language, the power must be explicitly granted. Section 8-2 discusses areas where zoning commissions have the authority to regulate. The commission was notified this in a letter that Mr. Art McNally read from Attorney Deborah Stevenson in 2012. I was sitting right in that seat when it was read, and I went and looked it up not once, but 3 times since that date. You have to have granted authority by law. It's not this is what the statute said. I read it. It's very simple. And adding to not only that issue, that you don't have the authority to do this, also that if you don't do this, you've already created a problem under item number 1. Item number 3. The current regulation 7.5.10I is unenforceable. The town attorney has already stated in writing the current regulation is a problem, not only in the 2010 opinion, there have been, now this is the 4th one we have tonight. The ZEO, zoning enforcement officer, cannot enter a property to measure a sign without a warrant. Something that is, and this you can say is in my opinion, cannot be granted. No court is going to give you a warrant to measure a sign saying Martin Overton should be defeated or Sean Murphy should be defeated. Not going to do that because it's silly. Number 4, this proposal addresses all the legal issues that have been brought up on political signs. It is consistent with the Connecticut Constitution and state statutes. The U.S. Constitution and federal case law is not relevant because the free speech protections from the Connecticut Constitution are stronger than the U.S. Constitution. That's not my opinion. That's the town attorney's. Came right from his letter. And because of that, which you folks are welcome to review, when you have a state right and a federal right, the stronger one prevails. Once again, not my opinion. This is what the attorney has said. So we start there. Then you go to the statutes. Then you go to local ordinances, and in terms of whether you want to talk about the plan of conservation, development, or zoning regulations. This commission does not have the legal authority to do something that is contradicted under state law. That's just the way it works. Item number 5. The zoning commission is charged to resolve this. It's not the court's job. It's not the job of the town attorney to write regulations. There is no case law from the Connecticut perspective, once again from the May legal opinion, not my opinion, that's what the town attorney said, because the rights under the Connecticut Constitution are so clear. Our rights do not come from courts. They come from our Creator. They do not come from government. That is, if you read the founding documents, that's where it comes from. If you're going to have courts saying, you have this, if you're going to have the court saying this is a right or not a right, you no longer have a democratic society, because if someone makes a law in Hartford you don't like, you can vote him out. If you have a judge who's appointed for life and says, oh no, the Constitution doesn't say this, it really says this, what's your recourse? I mean, it defies the basic common sense of voting in a democracy. And the discussion of using federal case law, we're a republic. Connecticut trumps the U.S. Constitution. That's what a republic is. I mean, this is back to the 1700s. Mr. Overton, you asked a question to Mr. McNally earlier about, and I'm only paraphrasing, I remember the exact language, about, what is the legitimate government purpose? Do I have that?
I did, yes.
Okay, thank you. Here's where it does come in. And if you look back into things I know I've said and other people have said on this commission, if you have a safety issue, regardless of what the sign says on it, you have a right to deal with it. If you put a sign up that blocks the exit of a driveway where you can't see the cars coming on, it doesn't matter whether the sign is pro-Martin Overton, against Martin Overton, or about Iraq. That's a safety issue, and there is settled law on that from Connecticut, down over on I-95 in Milford, where they had a billboard that was distracting driving. That makes complete sense. I think anyone would agree with that. The other thing that the Zoning Commission does have the right to do, and the one example I've heard regularly from folks, is signs that are internally lit, whether it's neon signs or signs with a light bulb behind them. When you're doing something like that, you're not affecting the actual message, you're affecting how the message is delivered. And if you put up, my area has lights, but if you take a residential neighborhood that's totally dark, and you put up a sign that says, you know, go Yankees, and it's blinking all night, that's disrupting the neighborhood. It's out of place for the neighborhood. If people don't have, you know, blinds or curtains on their house, you're going to just, that's what that is designed for. But that standard is so high, in order to take a right away. You don't, and you can just read it from any number of constitutions, federal or state, they address it. You don't have a right to do something that violates someone else's rights. Where we're getting into these discussions about legitimate government purpose, there is none. There's no right. Why this was ever put in the first place is beyond me. The only problem that's ever come up since 1996 when this came in that I'm aware of and that's ever been said at any of these meetings is Mr. Harris's sign for Martha Dean. And my recollection is that a member of the Democrat Town Committee said in a meeting here not too long ago, every member of the Democrat Town Committee complained about a sign that was for a Republican. That's been the problem. And then the complaints I've heard, well, I don't like it, I don't want to look at it. Well, that's not, I mean, where do you end that? Maybe I don't like people with blue shirts. Should I not be allowed to wear blue shirts? I mean, it just doesn't work. And that's what that is.
Could you answer one question for the commission? You made, everyone has a copy of this in front of them, so the commission has a right to regulate signs that internally lit, including political signs?
Anything. Because when you're dealing with something like a neon sign or an internally lit sign, and you put it in a using the example.
I heard your argument the first time, and I respect your argument, it's well thought out.
Yes.
But what I'm having a hard time with, and I'd like to explain to the commission and to the public, is first and foremost, I understand you to be saying, repeal all the signs, all the regulations related to political signs because it's a question of free speech. Then you're backtracking one step to say, accept internally illuminated signs. And I guess my question to you, for the purposes of clarifying, is which is it?
Well, we'll go back because I will tell you where I'm coming from. I support, outside of the two changes I proposed, which I think the second one's going to be done anyways about time limits, that if I support repeal of 7.5.10 as is. You can put in here,
I think my question was very narrow.
Well, but you did say something as if I were saying it, and I am going to address that, because in fairness, we're speaking on behalf of ourselves. So, I think it's a good idea to change the definition to include or a matter of controversy, which I think is going to happen. I have stated my opposition to the limits of taking the signs down because...
Can I just, because you're going over and over again, and maybe other people want to speak, but I'm not sure that you've actually responded to my question for clarification.
No, but I'm responding to the first thing you said.
If you are, well, let me just, that's one question. If a political sign is internally lit, is it your opinion that we have the right to regulate it?
Any sign, including political signs, I'm framing it, there's a reason why I'm framing it this way. Any sign, including a political sign, you have a right to outlaw as a zoning commission. Any sign that's internally lit, any sign that's not. It has to be done for all signs. And the reason why it does not contradict what I have said is it has nothing to do with the it's a presentation issue. If I need to put up a sign.
You need to wind it up. I'm getting signals from other people.
I understand that, but you're asking me a question, and not letting me finish, and then I'm explaining, and then you said something on my behalf that I'm finishing,
yeah,
and I'm answering your question.
Okay.
Okay. And you can